The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain some of the most common defenses to a breach of contract claim. So this is basically, when do you not have to perform a contract, or how can you get out of a contract? The first is when the other side materially breaches the contract. And it's important that it is a material breach, meaning something that defeats the purpose of the contract for you or defeats the benefit you'd be receiving, not a minor breach. So if Amazon's supposed to deliver something to you and it arrives a day late, that would be a minor breach, not a material breach. If it doesn't come at all, that would be a material breach. Anticipatory repudiation occurs when the other party says or does something that's inconsistent with their intention to perform on the contract. So this is, they contract with you to sell you a unique item, and then before the closing, they contract with someone else to sell them the same item. You can tell they don't intend to close on your contract, or they say, I'm not going to perform my end of the bargain. Well, you don't have to actually wait for them to not perform. Them just saying or doing something inconsistent with their intention to perform is enough to relieve you of your responsibility to perform under the contract. Unconscionability occurs when the contract is extremely one-sided in favor of the party with the more sophisticated party, or the party with superior bargaining power. This is a hard one to get through, this defense, but it usually occurs when a big bad company is taking advantage of a poorly educated consumer and making them sign a take it or leave it contract without consulting an attorney. Mutual mistake of material fact occurs when both parties believe this one thing about the subject of the contract, and it turns out they were both mistaken. So the example I use here a lot is one party is contracting to buy the Maltese Falcon from the other party, but they both don't know it's a fake, and they find out later on that it's a fake. They don't have to go through with the contract. If one party is mistaken and the other party should have known of their mistake and should have told them the truth, then that can be a defense too. But if one party is mistaken and the other party wasn't aware of the mistaken party's mistake, that's not a defense. So it's either a mutual mistake or one party's mistaken and the other party knew about it and didn't do anything about it. Similar is fraud. This is a misrepresentation of a material fact. So basically lying about something important to the contract to get the other party to sign, or an omission, so failing to tell the other party something important intentionally in order to deceive them into signing the contract. Undue influence occurs when one party exploits a confidential relationship or a particular vulnerability of the other party in order to benefit themselves. So this is, the classic example is a caretaking child for contracting with their parent to get their parents' assets at the expense of the other children. So it's when you exploit a special relationship that you have with somebody. Impracticability occurs when there's basically a third party or something out of the party's control, an act of God or something like that, that makes the situation on the ground impossible to perform the contract. So if I contract to build a house with you and then a tsunami occurs, flooding the land so that there's no land anymore to build the house on, then the contract is impracticable and I don't have to perform it. So those are the major defenses to breach of contract, but there are some other considerations if you're trying to get out of a contract that you're not happy with, other than just a straightforward defense. So one is a loophole. A lot of times if you have a lawyer review a contract, they can find a way to, something wrong with the language of the contract or some clause in the contract that can get you out of the contract. The more complex the contract is, the more likely there is to be a loophole, something you haven't considered as a non-lawyer perhaps reading the contract. Certain statutes invalidate certain contracts. So if a contract is illegal, or if it's basically a statute says that these types of contracts are invalid, then you don't have to perform under the contract. Sometimes one-sided clauses can be interpreted reciprocally. So an example is, in some states, an attorney fee clause that only benefits one side and says, if there's a dispute, party A gets their attorney fees and is silent as to party B will often be interpreted as a reciprocal attorney fee clause. So if the contract is very one-sided in favor of one party, there's a chance that some of the things that might get you out if they were reciprocal might be interpreted reciprocally. Most importantly, probably, is an ambiguous contract. So a contract that is unclear on what is required of each side exactly is one that may not require performance. And that's why it's important to have an attorney draft your contract, because one of our main jobs when drafting a contract is to make sure that it's not ambiguous, that each side's obligations under the contract are crystal clear. Because if it is ambiguous, then it's easy for one side to get out of performance. Finally, if there's been a change in circumstances, you may want to consider negotiating a modification of the contract. Sometimes the other party will be willing to change the terms of the contract based on changed circumstances, and a modification of the contract might be a more favorable outcome than breach of contract litigation. So if you have any questions, please leave them below our post at learn-about-law.com or below the YouTube video. We try to answer them on our website within about 24 hours. If you'd like to schedule a free consultation, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in nearly every area of law, and we have offices all around Chicagoland for your convenience. And finally, if you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud. Thanks so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.